Welcome to Casa Academy Chapter 5, Part 1, where we will cover real estate brokerage activities and procedures. I'm literally so excited to guide you through this material today because, well, it focuses on a massive part of your future career, exactly what real estate brokers can and absolutely cannot do under Florida law. From an exam perspective, let me be crystal clear. This is one of the most important chapters in the entire course. You are definitely going to see a significant number of questions based on these exact concepts. So grab your notes, get comfortable, and let's make sure you nail every single detail. To make all this easy to digest, we've broken it down into 6 logical categories for this explainer. 1. Brokerage offices and signs. 2. Real estate advertising rules. 3. Escrow accounts and deadlines. 4. Resolving escrow disputes. 5. Earning and claiming compensation. And finally, 6. Permitted business entities. Let's get to it.
Section 1. Brokerage offices and signs.
Okay, let's dive right in. Before a broker can even think about doing business, they've got to establish a compliant physical presence. So what exactly qualifies as a broker's office? Well, according to Chapter 475 of the Florida statutes, you can't just, set up a folding chair on the sidewalk and call it a day. A broker's primary location, which we call the principal office, has to consist of at least one enclosed room. It needs a designated area where negotiations can actually take place in private. Plus, this principal office absolutely must be registered with the Florida Department of Business and Professional Regulation. You're going to hear us refer to them constantly as the DBPR. Now, if the broker decides to expand and open up additional locations, those branch offices have to be registered too. Finally, and definitely star this in your notes because it's highly testable, every single office must display a sign on or near the entrance. The public has to be able to clearly identify the location as a legitimate real estate office.
Moving on to Section 2, Real Estate Advertising Rules. So, now that we've got a physical office set up, how does a brokerage actually get customers? Advertising, right? But Florida law demands absolute transparency here. There's this concept called a blind advertisement. Basically, this is an ad considered false, deceptive, or misleading simply because it conceals the exact registered identity of the brokerage. Every single advertisement you put out into the world must contain the name of the brokerage exactly as it is registered with the DBPR. It also has to clearly indicate that the ad was placed by a real estate broker. If you forget to include this precise info, boom, your ad becomes a blind ad and you're in trouble. And please keep in mind, this rule applies to way more than just old-school newspaper ads or yard signs. It strictly governs your online advertising, your custom websites, social media posts, literally all digital marketing platforms.
Section 3. Escrow accounts and deadlines.
All right, when your marketing actually works and a contract is signed, money starts changing hands. And this is where the rules become incredibly strict. When a buyer signs a contract, they usually provide a deposit as evidence of good faith. But think about it. Since the transaction hasn't closed yet, whose money is it? Actually, neither the buyer nor the seller has control at this point. Instead, the broker holds this money in trust, which we commonly refer to as escrow, until it can be properly dispersed at closing or, if the contract terminates. Because you are holding other people's money, the Florida Real Estate Commission, or FREC, monitors these accounts like a hawk. Seriously, violations here frequently result in some severe disciplinary action. But here's a really crucial point. Brokers are actually not required to maintain an escrow account themselves. They can totally opt to have a title company or an attorney hold the deposit instead. If a broker chooses that route, they avoid the heavy burden of maintaining the account, but they still have to follow specific procedures, like obtaining written verification from the title company, just to ensure everyone knows exactly where those funds are at all times. Now, if a broker does accept escrow funds, the clock starts ticking immediately. Let's break down this highly tested timeline because by law, the word immediately has a very specific definition. Imagine a buyer hands a deposit over on a Monday. The day of receipt actually does not count. Moving to step 2, the sales associate who received it must deliver those funds to their broker no later than the end of the next business day, which would be Tuesday. And speaking of making note of important details, your verification code is 951753. Now moving on to step 3, the broker's deadline to actually deposit those funds into the escrow account is no later than the close of business on the 3rd business day following receipt. So, excluding Monday, those 3 days are Tuesday, Wednesday, and Thursday. That means the broker absolutely must deposit the funds by Thursday evening.
Section 4. Resolving escrow disputes.
But what happens when things don't go according to plan? Imagine a transaction just completely falls apart right before closing. The buyer demands their deposit back, but the seller claims the buyer breached the contract and insists the money belongs to them. So who gets it? This scenario brilliantly illustrates a vital rule. The broker cannot simply play judge and decide who gets the money. Instead, the broker's immediate responsibility is tied to one specific number, 15. The broker has exactly 15 business days to formally notify FRAC that an escrow dispute is taking place. Once FRAC is officially notified, the broker then has to initiate one of 4 authorized settlement procedures. First up is mediation, which is basically just an informal negotiation process to try and work things out. If that fails, they might use arbitration, where a neutral third party steps in and makes a binding decision. Then there's litigation, which is formal court action, basically filing a lawsuit. And finally, there is the escrow disbursement order, commonly called an EDO. In an EDO, FRAC directly issues a directive detailing exactly who gets the funds. To put that into perspective, an EDO is one of the most commonly used methods for safely and legally resolving these tricky escrow disputes down in Florida.
Section 5. Earning and claiming compensation.
Okay, let's talk about something everyone is definitely interested in. How do you, as a sales associate, actually secure your paycheck? First and foremost, to legally earn any compensation whatsoever, you've got to hold an active real estate license. But here's where we see a major rule for both your state exam and your real-world practice. All compensation earned by a sales associate must flow entirely through that associate's registered employing broker. No exceptions. So, if a commission goes unpaid, can you just grab a gavel and sue the customer yourself? Absolutely not. A sales associate can never, ever sue a customer or consumer directly for unpaid commissions. Your legal and professional relationship is exclusively with your broker. Therefore, if money is owed to you, any legal claim for unpaid compensation must be directed solely against your employing broker.
Section 6. Permitted business entities.
For our final section, let's zoom out just a bit. Who exactly are you working for? Let's examine the legal corporate structures that are actually allowed to operate in Florida real estate. The simplest form is a sole proprietor, which is really just an individual operating alone with full responsibility for everything. But, when multiple people want to operate together, they definitely have options. The entities allowed to broker real estate include general partnerships, limited partnerships, corporations, limited liability partnerships, and limited liability companies. Now, each of these has totally different tax considerations and liability protections. However, the crucial point you need to remember is that to conduct brokerage activities, these specific entities must officially register with the department and adhere to some very strict Florida laws regarding ownership and control.
And honestly, just as important as knowing who can operate is knowing who cannot. You really need to memorize this list. Cooperative associations, business trusts, and joint ventures are strictly prohibited from brokering real estate in the state of Florida. Just flat out not allowed. Finally, we really have to warn you about this dangerous trap called an ostensible partnership. Now, an ostensible partnership isn't an actual legal business entity that you file paperwork for. Rather, it's a behavioral situation. It happens when 2 or more individuals basically act like partners and lead the public to mistakenly believe they are a formal partnership. So, why does this matter? Well, because if a dispute arises, a court may look at that and treat you as legal partners for liability purposes. You could literally end up taking on someone else's legal obligations simply because you shared a desk and a sign, and the public thought you were partners. Real estate professionals must avoid this at all costs to prevent disastrous, unintended legal liabilities.
We have covered a tremendous amount of ground today, navigating specific duties, incredibly strict deadlines, and rigid procedures. But I want to leave you with this question. Are you simply learning these regulations just to pass the exam, or are you actually preparing to safeguard the trust of the public? Understanding these rules ensures that when you step out into the real world, your brokerage activities are conducted properly, ethically, and in full compliance with Florida law. Thank you for joining me for this explainer on Casa Academy's Chapter 5, Part 1. Keep reviewing these slides, and I will see you in the next section.